The Supreme Court bench, headed by the Chief Justice, put a halt on the trial court proceedings in this case. It also asked for the survey report when it comes to the Sambal Mosque to not be made public, and it has asked the petitioners to appeal to the High Court directly. Now, can this be called an intervention? Let's say the High Court also says, as has happened with other cases, yes, please go ahead with the survey. Are we then saying that the Places of Worship Act has been rendered redundant? Let's also remember that in the Ayodhya verdict, when the Supreme Court granted Hindu groups the right to build a temple, and that temple is now, of course, there at the site per the directions of the Supreme Court verdict argued that the Places of Worship Act was located within the basic structure of the constitution, which means tomorrow a government can't come and just change it. That was the Supreme Court's own argument. Is the Supreme Court sending mixed messages, and is that the problem?
That is one of the problems. You see, the Ayodhya judgment was a very carefully crafted one. And it was in the peculiar facts of that case. The Ayodhya case had gone on for years. There had been a whole host of bloodshed from the times of the Ayodhya movement led by Mr. Advani. And in a sense, the country was also tired of it. So it was an attempt to put the genie back into the bottle. You must also remember that during the course of the Ayodhya hearing in the Supreme Court, there was a mediation attempt. Ravi Shankar, Justice Khalifullah, and Sri Ram Panchu, they heard both sides and they almost came to a settlement, which unfortunately could not be signed. The ultimate order that the Supreme Court passed was almost the same thing that had been put in the settlement. Those were the contours of the settlement were there. But the Supreme Court couched it in correct legal terms. It said that both sides proved their cases. Both sides were given decrees. But the execution of the decree, the Supreme Court used its special powers under 142 of the Constitution and said, okay, to avoid future controversy, the Hindu side will get the site on which the temple can be built. The Muslim side will be compensated with twice the land elsewhere. So, and in the course of this long 1,000-page judgment, which was possibly authored by Justice D.Y. Chandrachud, they also upheld a constitution bench unanimously. They upheld the Places of Worship Act. They said that the principle of non-retrogression there was the correct principle, and that we could not forever have all these kind of conflicts about what happened in the past and trying to undo them in the present through the courts. So, given all this careful balancing act, one would have thought that the genie went back into the bottle. But no, the messaging, the general message that people seem to have taken us, that, look, it's all right to claim a place of worship. You can always push the other side somewhere else or push them totally out of the frame, as it were.
But Sanjay, if I may ask you, Justice D.Y. Chandrachud was widely believed to be the author of the Ayodhya verdict, but it was also Justice D.Y. Chandrachud who allowed the Gyanvapi petition. He did not state the petitioners at that time. The Muslim groups argued that this is a violation of the same Places of Worship Act that Justice Chandrachud had reinforced in the Ayodhya verdict. Has the Supreme Court been contradictory? Has the Supreme Court contradicted itself, which is why we are in this situation today?
One must remember that Justice Chandrachud passed no such order. He did not pass a judgment. It was an oral observation.
Yes.
In the course of hearing, when the argument on the Muslim side was, look, these suits can't go on, because if you cannot give any relief in the suit, if you cannot change the character of the place because of the Places of Worship Act, then these suits are frivolous. They should be dismissed right at the outset. That was the argument. But responding to that argument, you know, we men and women of law are often very clever at splitting hairs. So there was a possible argument which occurred to Justice Chandrachud said that you, of course, you can't change the character of the place, but surely you may determine what was the character of the place on 15th of August 1947.
Yes.
Sometimes uh, unwarranted word and unwarranted comment, and especially from a Supreme Court judge, has disastrous consequences. That is why whenever we go to the Supreme Court, the first thing I tell clients is that I follow the Hippocratic oath. First, do no harm. Be careful about what you pray for or what you ask. Because any response from the court then has consequences throughout the country.
You're correct that Justice Chandrachud made that comment orally. He said, in fact, if I remember correctly, this is an interlocutory order. Why are you concerned? We are not changing whether this is going to be we're not changing this from a mosque to a temple and so on. But are you saying, and then I have to go to Ashwini and Zafar Bhai, Ashwini ji and Zafar Bhai, are you saying that Justice Chandrachud's oral comments in the Gyanvapi case hearing has had disastrous consequences?
I am saying that. And I'm saying that as somebody who deeply admires the judicial wisdom, the written judicial wisdom of Justice Chandrachud. I'm saying that as a student of Justice Chandrachud. He was my professor of law. And I'm saying that, as a lawyer of long experience, that we lawyers sometimes tend to get over clever by half. And we don't let go of that habit even if we sit on the bench.
Okay, so that's a big statement.
This was an unguarded one. This was an unguarded comment which has had disastrous